Joint tenancy in Singapore. Assalamualaikum. A common challenge faced by Muslims in Singapore is the handling of a joint tenancy property upon the death of a joint tenant. This video will help you to understand what joint tenancy is according to Singapore law. The information presented here is based on research and books written by Sadali Rasban. Joint tenancy is an agreement between two or more parties who co-own a property. The agreement is signed at the point of buying the property. According to the state law, the co-owners are required to be well informed of the nature of the agreement before they sign the agreement. All parties have equal and undivided interest in the property, regardless of payment made by each party. In other words, there is no definite share owned by each joint tenant, such as 50-50. Joint tenancy follows the principle of survivorship. Under this principle, when one joint tenant dies, the surviving tenant or tenants will take full ownership of the property. This means that the property cannot be distributed to other legal heirs by any means, including the Muslim Faraid system. In Singapore, joint tenancy applies to all immovable property. This includes public housing, such as HDB flats, private housing, as well as commercial properties. At this moment, joint tenancy contracts are not applicable to Malaysia for immovable property. Joint tenancy is applicable to all, regardless of religious belief. This means that even fatwas issued by MUIS will have no impact to joint tenancy law. Here are more characteristics of joint tenancy. A joint tenancy contract can be severed unilaterally without the consent of other co-owners. This allows each joint tenant to reconsider the inheritance process without getting the approval of other joint tenants. The severance of joint tenancy will convert the co-ownership to tenancy in common. For example, if a man decided not to have his wife take over 100% of the property, he can sever the contract without his wife's approval. This means that he will have 50% share of the property, whereas his wife will have the other 50%. When he dies, his wife will keep a half of the property, whereas his half will be distributed to his legal heirs according to Muslim law. Under joint tenancy, the transfer of ownership of the property does not require a probate. The probate is a process of appointing an executor or an administrator to legally manage the deceased estates and the proper transfer of the ownership of the property. This process is often costly and lengthy. In contrast to that, under joint tenancy, the surviving joint tenant can simply go to HDB or their lawyer to have the property transferred to himself or herself. For Muslims, an Islamic will cannot be applied to inheritance process of a joint tenancy. For example, if a man and his wife are joint tenants of their property, when he dies, the property will be transferred to his wife, even if he had made a valid Islamic will to give the property to others. In addition, a joint tenancy also cannot be distributed based on the Muslim Faraid system. As in the previous example, other legal heirs of the deceased cannot inherit the property that is under joint tenancy. The property will only go to the surviving joint tenant. Challenges for Muslims. With many Singaporeans owning a property under a joint tenancy contract, joint tenancy becomes a challenge for Muslims in Singapore. Among the common questions that Muslims here have are: is a joint tenancy Sharia compliant? Does it conform to Islamic principle? What are MUI's fatwas on joint tenancy? Does it accept it or reject it? What are the implications of MUI's fatwas on joint tenancy? Are the proposed nuzia by MUIS on joint tenancy Sharia compliant? Can Muslims reject the fatwas? Can we embrace joint tenancy in Muslim law? For more information, watch the next video in our video series or contact us directly at HT Advisory Services. Thank you for watching.